Jill Court, do we need to test your microphone? And your video?
How about now?
I can hear you now.
All right, that's good. I just had it muted.
Okay. Okay.
Do I start video? Do I have to invite anybody or just start video?
No, you don't have to do anything. Just start your video probably in about 5 minutes or so.
All right, got it.
Hey, Wynette,
Wynette.
Yes.
by chance did the DA send you any paperwork on Mitchell?
They just sent me that one paper.
Okay.
Hang on, let me look to see. Yeah, I didn't get like everything else, I just got the stipulation.
Okay, thank you.
Uh-huh. Karen, Mr. Hartwell's connected if we need more paperwork.
She's sending him an email.
Okay.
Thank you.
Uh-huh.
Ready? Start video. Move out of the way.
I will need to adjust that camera up. All right, good afternoon, Ms. Manning.
Good afternoon, Judge.
Who would you like to call first?
Judge, we can start with Mr. Audie Yarborough.
Mr. Yarbrough, if you'll come forward, please. All right, this is in cause number CR 23-195, State of Texas versus Audie Bailey Yarbrough. For plea, Mr. Yarbrough, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. All right, sir, is your name Audie Bailey Elmo Yarbrough?
Yes, sir.
And Mr. Yarbrough, are you a United States citizen who reads, writes, and speaks English?
Yes, I am.
Have you ever been diagnosed with any type of mental condition? Is that a no? I'm sorry, it kind of cut out. Is that a no?
Yeah, no, sir.
Okay. In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation of you?
Yes, I am.
Do you feel like you've had enough time to talk with him about your case? You understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. Manning, do you believe Mr. Yarbrough to be competent today? And if so, that you've explained to him his rights as they pertain to this case?
I do believe he's competent, that he has understand my explanation of his rights. We've had multiple discussions about his case, and he's been able to participate in preparation of his defense and negotiation of this plea.
Okay. All right, Mr. Yarbrough, you were originally indicted with a second-degree felony burglary of a habitation. However, it appears that in your plea agreement, the state's recommending that you be prosecuted for a lesser offense of Class A misdemeanor assault causes bodily injury of a family member, wherein they're recommending that upon your plea of guilty that the court convict you of that offense and sentence you to the maximum 365 days or 1 year in the county jail, and then for the court to suspend that sentence and place you on community supervision for a period of 1 year. In addition, you would have to pay a $100 fine, court costs, and reimbursement fees of $520. Is that your understanding of the plea agreement, Mr. Yarbrough?
Yes, sir.
All right. Mr. Yarbrough, then understanding the range of punishment, which is a maximum 365 days or 1 year, and a fine which cannot exceed $4,000, the court finds that this plea agreement fits within the lawful range of punishment. Mr. Yarbrough, how do you plead to the Class A misdemeanor offense of assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor. Although for the court's information, I guess, yes, the victim in the case is supportive of the plea.
Great, thank you. I was going to ask that question. I appreciate that, Mr. Arlo. Anything further from the defense? Okay, the court's going to review the evidence. All right, based on the evidence presented, the court finds that there is enough evidence to convict the defendant of this offense. The court will follow the recommendation of the state in the plea agreement. The court hereby convicts Audie Bailey Elmo Yarbrough of assault causes bodily injury of a family member. Court, that is a Class A misdemeanor, and the court assesses punishment at the maximum 1 year in the county jail. Court will suspend that sentence today and place Mr. Yarbrough on 1 year community supervision, ordering him also to pay a $100 fine, $270 court cost, and $520 in reimbursement fees. Mr. Yarbrough, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of this sentence. I'm gonna have you step over with the deputy to be fair. Who would you like next, Mr. Manning?
Judge, ready, Mr. Jaquavian Rogers?
Jaquavian, Trevin, or it's probably Trayvon Rogers, cause numbers CR 23-240, CR 23-241, CR 23-242, CR 23-243, CR 23-245, CR 23-244, 247, and CR, I don't know if I said 46, but that one is one. All right, so let me see if I can see what we got going on. All right, Mr. Rogers, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Is your name Jaquavian Trayvon Rogers?
Yes, sir.
Mr. Rogers, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
Yes, sir.
Have you had enough time to talk with him about all of these cases to the point that you're satisfied you understand everything in your plea agreement today, your rights, and everything that you've agreed to in this paperwork?
Yes, sir.
Mr. Manning, you believe Mr. Rogers to be competent?
I do, Judge. We've had opportunity, as I may have mentioned before, had an opportunity to go over discovery in his case. He understands the allegations against him, and he's been able to discuss possible defenses as well as mitigation in his case.
Thank you. All right, Mr. Rogers, it appears that you've been indicted with a second-degree felony offense of aggravated assault, deadly weapon. In 7 separate indictments, also deadly conduct or discharge of a firearm, third-degree felony. It appears today that the state is recommending to the court that in cause number CR 23-244, aggravated assault deadly weapon, that the court, after considering the evidence and your plea of guilty, that the court not convict you today, but defer a finding of guilt, place you on 6 years community supervision, finding you $1,000, and the state is agreeing to dismiss the other charges of aggravated assault and also the deadly conduct or discharge of a firearm with anger management as a condition of your community supervision. We'd also be responsible for your court costs and reimbursement fees. And then in cause number CR 23-246, you would be pleading guilty to a lesser included offense of assault causes bodily injury of a family member, with your punishment being assessed at 147 days in jail, with you receiving credit for 147 days of time served, In addition, you would have a $100 fine plus court costs and reimbursement fees. Is that your understanding of the plea, Mr. Rogers?
Yes, sir.
I have to admonish you that the range of punishment for a second-degree felony, if convicted and sentenced, the minimum would be 2 years in prison, the maximum could be 20 years in prison, and you could also have a fine of not more than $10,000. In your Class A misdemeanor case, the range of punishment is maximum 365 days with a possible maximum fine of $4,000. So do you understand, Mr. Rogers, that if I, in a moment, I want to hear the evidence, and if I approve the plea agreement and place you on deferred community supervision, if during your period of supervision, you violate any of the terms or conditions, the state of Texas can file a motion, bring you back to court, put you through a hearing, and if the court presents evidence, if the state produces evidence to the court that you violated any of your terms and conditions, the court can do a number of things, including convicting you of this offense, revoking you off of community supervision, assessing your punishment anywhere from the minimum 2 all the way up to the maximum 20 years in prison. You do understand?
Yes, sir.
Okay. Understanding that, Mr. Rogers, let me ask you, how do you plead to aggravated assault with a deadly weapon, a second-degree felony?
Guilty.
How do you plead to the Class A misdemeanor offense, assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty to either one of these crimes?
No, sir.
The court accepts the defendant's plea of guilt in each case respectively. Mr. Manning, any objections to the stipulation of evidence in each case?
Judge, no objection per se. There was a clarification on the stipulation of evidence. In going over that with him, he said that the weapon was only fired 3 times instead of 4, as is in the stipulation of evidence. I told him that while that's not dispositive, that I would bring that up to the court. That if you fire 1 time, that's sufficient enough for this offense. But he did clarify that it was not 4 times as in the stipulation of evidence, but 3.
And your honor, state would have no objection to interlineating the stipulation to amend it to say 3 instead of 4.
Okay, very well. Anything further, Mr. Manning?
Nothing from defense.
All right. Anything further from the state?
Your honor, just that the victims in the case are supportive of the plea, and actually requested probation specifically for this case.
Thank you, Mr. Arnold. All right, court's going to review the evidence. Is the stipulation the same in each case?
No, Judge.
Different? Okay.
Yes,
All right.
Judge.
Court will review the evidence in each case. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict Mr. Rogers of both of these offenses. The court will follow the recommendation of the state, understanding that the victim in these cases are supportive of the agreement between the defendant and the state. Court to provide cause number CR 23-244 on the charge of aggravated assault deadly weapon. The court defers the finding of guilt, places Mr. Rogers on 6 years of community supervision, orders him to pay a $1,000 fine, and the court dismisses under section 1245 the remaining indictments for the aggravated assault deadly weapon as outlined in the court's judgment, and also the deadly conduct discharge of a firearm. As a special condition of community supervision, that Mr. Rogers is to take anger management as a condition of his community supervision. Further, the court orders him to pay a $1,000 fine, $290 court costs, $520 in reimbursement fees. In cause number CR 23-246 on the charge of assault causes bodily injury of a family member. The court finding sufficient evidence to convict the defendant hereby follows the plea agreement, convicts Mr. Rogers of assault causes bodily injury, family member, a class A misdemeanor, assesses his punishment at 147 days in county jail, awards him 147 days credit for time already served, orders him to pay a $100 fine, $270 in court costs, and $20 in reimbursement fees. Mr. Rogers, you are hereby remanded to the custody of the sheriff and the probation department so they can carry out the terms and conditions of the sentences. Please step over with the deputy to be fingerprinted on each judgment.
Judge, if I may have just a brief moment, before we
Yes, sir.
proceed on my other cases.
Yes, sir, no problem.
There's no word.
We'll find out. I'll figure that. No question. You don't have one, you have an ID? What town? What's your, how much?
Are you ready on the screen?
Judge, ready on Mr. Sprouse? Okay.
Officer CR 23-17, Michael Raymond, is it Spruce or Sprouse?
It's Sprouse, Judge.
Sprouse?
Yes, sir.
All right, Mr. Sprouse is set for arraignment.
Judge, my client understands the charge against him, the range of punishment. At this time, he's going to be pleading not guilty and request to be set for pretrial.
All right, court will find that Mr. Sprouse has waived the formal requirements of arraignment. His name is spelled correctly, and he understands what he's charged with. The court will enter his plea of not guilty into the record. We'll set this matter for pretrial hearing on March 28th.
And Judge, if we're able to figure out something before then, would the court entertain him being reset sooner than that?
Yes, absolutely. You're welcome, sir.
Judge, next ready on Mr. Del Cambre.
Mr. Del Cambray, if you'll come forward. This is cause number CR 24-4, State versus Mark Lane Del Cambray for arraignment.
Yes, Judge. I've had opportunity to go over some, but not all the discovery with my client. At this time, he enters a plea of not guilty, request to be set on the pretrial docket.
Is his name spelled correctly?
Yes, Judge.
All right, court finds that Mr. Del Cambray has waived the formal requirements of arraignment. His name is spelled correctly in the indictment that he understands what he's charged with. Court enters his plea of not guilty into the record and sets pretrial in this case on March 28th. Who's next?
Judge, I believe the last one I have is Mr. Williams.
Leonard Marshall Williams, CR 2372. All right, Mr. Williams, for the record, is set on the court's trial docket. I believe that he is,
Judge, he's specially set for trial on June 3rd of this year.
June 3rd, yeah, I was looking on March. So Mr. Williams is set for trial especially. And my understanding, Mr. Manning, is that you have filed a motion to withdraw as counsel. Is that correct?
That's correct, Judge. And just for the court's record, when that was originally signed, Mr. Williams signed off as agreed on that. However, it's my understanding through his communications with the court that he has no longer agreed to that. So I'm not sure what his position is at this point in time. But I would say, regardless of his position, I would still urge this motion to withdraw based on the reasons listed out in my motion. And they still do exist at this time.
All right, Mr. Williams, I'm going to give you an opportunity to speak here regarding any inability to communicate between you and Mr. Manning. What I want you to keep in mind is to not say anything about your case that in any way could affect your rights, okay?
Yes,
and
sir.
knowing that a prosecutor is involved in this hearing, so anything that you say obviously can be used against you in this proceeding, in subsequent proceedings, trial, okay? So can you address for me why it is that Mr. Manning is requesting to draw your case from your perspective?
I don't know why you want to withdraw. I don't have no problem, Mr. Manning. I only talked to Mr. Manning, this be my fourth time talking to him about my case. I don't got no problem with it. I just wanted him to give me my motion for my discovery, my paperwork. That's it. That's all I was asking for.
Mr. Manning, can I go ahead and have you go ahead and argue your motion?
Yes, Judge. I'd say that there are situations that have gone beyond what Mr. Williams has put on the record due to the fact that he's filed multiple complaints about my representation, not only with the court, but with the state bar. Additionally, Judge, I have explained to Mr. Williams in the multiple times that I've spoken with him in our preparation for the motion to suppress, which I did argue before this court previously, as well as our preparation for trial, that he is not entitled to be given discovery, but he can review the discovery with his attorney in preparation for both those hearings, as I said, as well as for trial. I've given him opportunity to discuss and prepare for defenses, but his timeline seems to be a bit different than what I've laid out for him. Additionally, Judge, he's expressed to me his displeasure with his speedy trial being set out to June. He wants the trial. He was requesting a trial date sooner than that. However, Judge, I've explained to him that we have gotten a special setting, which is a specific date for trial that is set by this court, and that's usually done at the earliest available opening. So we have certainty for both parties to be prepared and try that case on June 3rd. Judge, it's my position that if I were removed from the case, that Mr. Williams would have sufficient time to have either an additional attorney appointed or retained who'd be able to prepare for a trial hearing on June 3rd. That gives them well over 3 months to prepare for trial. In this case, the discovery and such that I've gone over, that would be sufficient time for additional counts to prepare for trial. Judge, I'd also just point out for the court that I believe I'm Mr. Williams' third attorney, and I can't speak to what the previous attorneys did or didn't do, but I know both Mr. Weiner and Mr. Stevens and their work product. So, Judge, at this point in time, I would re-urge my motion. I don't think that based on the actions that Mr. Williams taken, that I'd be able to represent him as ethically required to do under the rules and regulations of the state bar.
What is it that Mr. Williams is stating to the state bar? And you said he's filed multiple grievances against you.
Judge, he's filed a grievance as well as filed an appeal once that grievance was denied by the state bar.
And so what is he accusing you of, or what is he alleging?
Judge, I touched on some of those allegations, but without going into attorney-client privilege, I wouldn't be able to further divulge the totality of what he's alleging, but I did touch on some of those in our arguments earlier.
Mr. Williams, what are you alleging that Mr. Manning has done? You filed a grievance with the state bar, so you've asked the state bar of Texas to come in and sanction Mr. Manning for the way that he's representing you. What is it that you are asking the state of Texas through the state bar to do to Mr. Manning, and for what reason?
I wasn't asking him to do anything. I was just asking him to do his job. He said, after my discovery, he was gonna come see me. He called me out one day to get my mental health paperwork signed over before he can get the paperwork sent to him. He never sent it off. So I'm asking him, could he come and talk to me or something to let me know what's going on with my case? I had got him so quick after Justin that when we went to trial, we just talked that one time and that was it. He supposed to come and talk to me after we did the discovery. He never came and talked to me about the discovery at all.
Mr. Williams, can you just hire the attorney that you want to hire? If I
No,
give you
sir.
Why not? Why not?
Justin Warner took all my money.
You meaning that you retained him and then he withdrew?
Yeah.
For the same reason that Mr. Manning is wanting to withdraw, or for different reasons?
No, that was different reason. That with Justin got my money and just withdrew off of it.
Mr. Stevens represented you as well, is that correct?
Yes. The
And why-
Stevens never came to court. I just be trying to get some understanding. I'm a mental health patient, so I'll be trying to figure out what's going on. Come talk to me. Let me know what's going on with my case. In Dallas, if you got a case, you go on trial, I should be able to see you within that year, not the last 90 days, and we going over something to work up a case. I asked him to file a motion to suppress the evidence to the court. I never got that. I asked, all I asked him to come talk to me and let me know what's going on, where I can be at ease.
And Judge, if I may, just to be crystal clear, you can see in the court's record, I asked the court to take judicial notice of its record. We argued his motion to suppress, and I thought, and Mr. Williams thought at that time, that it went really well. We had some success, scored some points on that motion to suppress, even though the court denied it. We got some testimony I think is gonna be favorable at trial. But Judge, as I said, my timeline and his timeline seem to be on two different wavelengths, and his actions have made it more difficult to represent him rather than easier to represent.
I didn't know that to redo the board thing, I didn't know. I thought you're supposed to just fill it out and send it back. I didn't know it was it. I thought that was the end of it. But I mean, this what it got me. I apologize to him for making the job hard, but I ain't trying to make nobody's job hard. I just wanted to get an understanding about my case.
What is it about your case that you don't understand?
I'm trying to figure out what kind of move we gonna go through the court, if he gonna file, or what kind of action do we have? He said he gonna come talk to me after the discovery to explain to me everything what's going on, and I ain't never seen. He said, I see if we go to court, don't go to court in 2, and within 2 months, I get your bond reduction. I haven't seen, I'm just back there in my head, just, you know.
Do you
I
understand?
apologize to him if I caused any type of harm to him, but I wasn't trying to get no cause, no harm. I was just trying to find out information where he can come sit down and talk to me, where we can come with agreement, where I'll be ready.
I understand, but do you understand what Mr. Manning is saying?
Yes. I apologize, Mr. Man. I didn't mean none of this, sir.
What Mr. Manning has just said is that while he's been trying to defend you against the state of Texas, you've now put him in a position where he has to defend himself against the state of Texas. So the time that he should be using defending you, he's having to defend himself against you. You understand? You understand what kind of situation that puts him in?
Yes, sir. I didn't know, and I apologize. I didn't know. I'm sorry.
All right, Mr. Manning, I'm going to grant your motion. Your motion is granted. You're allowed to withdraw. Mr. Williams, I don't have anybody else on the court appointed list that can represent you. You've gone through them all. I don't have anyone else. So right now you have no attorney. I'm going to remove your trial off of the special. I'm going to put you at the very back of the jury trials, because I don't know when I'm going to be able to get an attorney. I don't know when I'm going to be able to try your case. So I'm going to have to go and try to figure all these things out. So these efforts that you've taken are going to delay your case even more. And it's through no fault of the court, it's through no fault of anyone else, but based on the actions that you've taken. So I will have my court coordinator reach out soon with paperwork for another attorney if I can find one. So I'm going to encourage you to reach out to your friends and family. If you can hire an attorney, then you hire one. If not, I'm going to need time to see if I can figure out how I'm going to get an attorney in here to represent you. You're on the you're specially set for June. I'm going to leave you specially set there, and then once I get a new attorney, I'm going to remove you from that special setting, and then we'll set you to another time. So at this point, your next court date will be June at the originally scheduled trial date, which was going to be you were supposed to go to trial on June 3rd. That's not going to happen now. So I'll try to see you before June 3rd, but I don't know when that's going to be. I'm going to have to go find a lawyer somewhere that'd be willing to take your case, and I'm sure they're going to want to investigate, talk to all these other attorneys that you've had to see if they may not even be willing to do it. So I can't tell you anything other than you're going to have to go sit and wait. Hopefully I'll figure out something soon.
Yes, sir. I'm sorry.
That's all right.
Yes, sir.
I ain't running out. Thanks. Oh. Well, I just want to get in trouble back there.
All right, Mr. White, are you ready on Mr. Mitchell?
Yes, sir, I am.
Mr. Mitchell, if you'll come forward, this is cause number CR 23-223, State versus Roy Mitchell III. We doing a plea today, Mr. White?
Yes, sir, we are. Would you like the terms of the plea bargaining agreement?
I think the only thing I have here is the stipulation of evidence. So yes, sir, if you can walk me through what the plea is.
Your Honor, we are going to plead to the lesser included of an attempted delivery of a controlled substance or marijuana to a minor. We are going to proceed under 1244A of the Texas Penal Code. Pursuant to our agreement, Mr. Mitchell received 163 days in the Van Zandt County Jail with 163 days credit, a fine of $1,000, court cost of $290, and reimbursement fees of $770.
Mr. White, are you appointed on Mr. Mitchell?
Yes, sir.
All right, Mr. Mitchell, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Is your name Roy Mitchell III?
Yes, sir.
And Mr. Mitchell, are you a United States citizen who reads, writes, and speaks English?
Sir.
Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White being your attorney?
Yes, sir.
Feel like you've had enough time to talk with him about your case to the point that you understand all of the paperwork and your plea agreement that you signed? Mr. White, do you believe Mr. Mitchell to be competent?
Your Honor, I believe that Mr. Mitchell is competent